we're going to talk about one of the hot issues that have been in the news for the past few months. And there's no clear answer to this, to all the questions that are coming up about this. Okay? We've got a great panel today. We have Peter Bybring. He's the Director of Police Practices and Senior Staff Attorney at the ACLU of Southern California. Peter's at the end. He's a Senior Staff Attorney, and he works on a wide range of police-related issues, including race and bias in policing, gang injunctions, excessive force, search and seizure, police interference with First Amendment rights, national security, civilian oversight, and surveillance. We have Andrew Crocker, Staff Attorney at the Electronic Frontier Foundation. Many of you know about the EFF's activities. Andrew's next to Peter. He focuses on EFF's national security and privacy docket, as well as the Coders' Rights Project. While in law school, Andrew worked at the Beckman Center for Internet and Society, the American Civil Liberties Union's Speech, Privacy, and Technology Project, and the Center for Democracy and Technology. Thank you both, gentlemen, for joining us. Gary Fagan, special guest with the glasses next to Andrew. He's the Chief Deputy District Attorney for San Bernardino County. Yes, ground zero, right there. He started at the San Bernardino County District Attorney in December 1977. Since 2008, he's been the Chief Deputy District Attorney for the Specialized Prosecutions Division of the District Attorney's Office, overseeing the appellate, asset forfeiture, child abduction, consumer and environmental protection, conviction review, electronic intercept, insurance fraud, real estate fraud, welfare fraud, sexually violent predator, mentally disordered offender, and staff development units. They've been keeping you busy, haven't they? And finally, Ronald Rather, Jr., partner at Troutman Sanders. Their information governance and privacy and financial services litigation practices. He's known as the interpreter between the business and information technology, guiding both parties to the best result. In his role, Ron has assisted companies in navigating federal and state privacy laws for almost 20 years. So we tried to assemble a panel with a variety of perspectives: business, law enforcement, and privacy supporters. So welcome, gentlemen. I think we got a great team. We're going to have time at the end for questions, so think about some things you might want to ask. I'm going to get started. I'm going to stop us at a decent time. If none of you have questions, I'll just make some stuff up. But I'm assuming you will. So let's get going. On December 2nd, 2015, 14 people were killed, 22 seriously injured in a terrorist attack in San Bernardino, California. On February 9th, the FBI announced that it was unable to unlock the terrorist San Bernardino County-owned iPhone 5C, which was running iOS 8. So what were the responses? The federal judge issued a court order mandating Apple to create a new version of their phone's operating system to bypass encryption. Apple objected, citing its policy to never undermine the security features of its products. That's where the interesting discussion started. On February 19, 2016, the U.S. Department of Justice filed a new federal application to compel Apple to comply with the order, citing the All Writs Act of 1789. Yes, 1789. Most of you know about that, but that's quite interesting. Andrew, did you want to say anything about the All Writs Act? I know we had a little chat about that.
Sure. So, just on that issue of 1789, I think there's been some joking about it being an old statute applied to this sort of newfangled technology, and as I think the Justice Department pointed out very rightly, it's not not a novel idea to apply old laws to new situations. That's what we do as lawyers, and in fact, the Constitution is also from that same year. But what was sort of novel here is what Apple was being asked to do. They were being asked to write new code and then sign it with their private software signing key so that it would run on the iPhone. And in the history of the All Writs Act, the 200-plus year history of the All Writs Act, it had never been used in that way. And what the All Writs Act is sort of for is to issue writs necessary in the aid of a court's jurisdiction. So it's a gap-filling statute. That's how courts describe it. And, the sort of most directly relevant case that everyone agrees was directly relevant was from 1977. It's called New York Telephone. And there, a telephone company was asked to issue an All Writs Act, in compliance with an All Writs Act order, to install a pen register, a sort of a simple device for tracking the numbers dialed on a telephone. And it was in aid of a search warrant issued in a criminal investigation. And what the Supreme Court said there is, because the telephone company's services and facilities were being used as part of this crime that was being investigated, and because it would be very easy for the telephone company to install this pen register on its facilities, and because there was really no other way for the police to track the numbers that the suspect was dialing, these were all reasons that supported the issuance of this All Writs Act order, and the Supreme Court said they had to comply with it. That's sort of the way the All Writs Act is used in this kind of context, in the law enforcement investigations context, to effectuate search warrants, but to do it in a sort of a gap-filling way where it's not a very burdensome order issued to a third party. And that's really the sort of the source of this debate, is how burdensome was it on Apple? Was it unreasonable? And would it compromise other interests that Apple had, including maybe, in fact, its First or Fifth Amendment rights under the Constitution?
Well, I don't engage in federal practice, but San Bernardino County had some compelling interests in getting involved in this, and to us, the All Writs Act is kind of a diversion. We had a compelling interest to get real evidence. This wasn't some theoretical problem for us. We had 14 people, citizens of our county, that were murdered, 22 that were wounded, and a room full of other people that were hurt. It was very real to us. One of the lawyers in our office, husband, was in that room. The person to the left of him and the person to the right of him were both shot dead. He survived. We had information that there might have been another shooter that was undetected that we felt we needed to get into that area. As far as the concept, in big picture concept, that a corporation can resist a federal court order or a search warrant because it was inconvenient or they didn't feel that it was in their business interest, for most prosecutors and law enforcement, as a repulsive concept. You don't get to thumb your nose to a lawful court order, and so there has to be some means to effectuate that order. And whether, to us at least, the All Writs Act was really a federal litigation issue that didn't really address the issues, and frankly, some of the arguments that Apple addressed are not well-founded in our view. We can talk about those later if you want, but at some point I'd like to talk a little bit about the practical effects in your communities of this problem.
Let's go back a second, a little history. Just, some of the things that have been occurring in this country. The Communications Assistance for Law Enforcement Act passed in 1994. That required telecom carriers to maintain the ability to wiretap, for law enforcement, communications carried over their networks. Okay, carriers were not required to decrypt communications unless the encryption was provided by the carrier and the carrier possesses the information necessary to decrypt the communication. This was all before the internet, of course, right? Before Apple, before Google. And so this is what often happens in our country. Legislation lags behind technology. And it will always be that way because technology moves too quickly and people in politics tend to take their time, discuss things. It's just the nature of the way it is. And that's why we're always struggling. And this isn't the first time, right, that we've had issues like this. Communications that went across the internet, as I said, instant message, video chats, emails, no legislation on that. Encryption is being discussed. We've seen Dianne Feinstein, for example, and some other politicians proposing things. Every time I see them trying to legislate the internet, I cringe up because they're way behind. They just don't get it, right? And it's up to technologists like us to talk to our elected officials to keep them informed. It's very important because they're focusing on other things. We're the experts that they should be relying on. In fairness, the U.S. government wants visibility into all communications. Whether they should have it or not, I don't know. I said in fairness, right? Some evidence necessary to an investigation, such as this case, will not be available because it is encrypted and the provider lacks the key to access it. All right? Apple, for example, could not today, with their technology, access this information. Now, if it was backed up in iCloud, they probably could. There's a difference, right? Yes?
Apple never said that. Apple never said that they couldn't do this. None of the documents that they filed in court said that it was impossible. They said they don't choose to do it.
Okay.
Well, I would draw a distinction between whether they can decrypt the information on an encrypted phone and whether they could write the code that would allow the FBI to brute force the phone, which is what the third party did in the end. The type of encryption scheme that Apple is using, practically, they aren't able to decrypt it. That's what they've said in their public filings and, in their guide to the public. I don't know if you wanted to add something to that.
Yeah, I mean, well, yeah, we're getting into this now. I mean, I think it's worth noting a few things about what this case is not about. So nobody argued that the federal government didn't have a right to access the information in the phone, in the sense that there was nobody was arguing that there was some kind of privacy interest that prevented that, right? I mean, the federal government, when it gets a warrant because it has probable cause to believe that there's evidence of a crime, can get into phones. And clearly, in this case, there was very clearly probable cause. The issue, of course, was whether Apple could be compelled to break its own security systems. And I think the issue there is a different one. It's not about whether a corporation can just thumb its nose at the federal government and say, we don't want to do what you want to do. It's about how important is encryption, how important is security. And if you look at the briefing, the difference between the briefing, the place that I think the pro-privacy parties like EFF, the ACLU, and Apple, and others differed most from the federal government was in the value it placed on encryption. If you look at, and this folds into the All Writs Act and the argument, the legal argument pretty cleanly. One of the things the court looks at is the burden that is placed on a party in deciding whether it can compel compliance under the All Writs Act. And if you define burden the way the federal government did as an expenditure of resources by Apple, it's probably not the biggest burden. I mean, take a team of, they said 10 people about 4 to 6 weeks, right? So for one of the world's largest corporations, that's probably not a huge expenditure of resources, and I think that everybody kind of recognizes that. But Apple didn't want to, it wasn't that Apple didn't want to expend the resources, it's that it didn't want to break the security system that it had spent time developing. And why is that? Well, there's a couple of things. First of all, in the law, there's not a detailed gradation in terms of probable cause between national security cases and other cases. And I'm sure that all of you saw the press that in addition to wanting software that would break encryption, in this case, there was a long line of local district attorneys, including the San Bernardino district attorney, the Manhattan U.S. attorney, and others who wanted to get into iPhones that they'd been unable to get into in ordinary criminal cases. If you do it in a national security case, the next case is a drug cartel case, the next case is an ordinary drug case, the next case is a tax evasion case. And pretty soon, every local prosecutor has a way to get into an iPhone, and you all, I think, as security professionals, probably know better than anyone that once that software is readily available to prosecutors' offices in every town in America, it is pretty well available to criminals as well. And so the security features that Apple has been building in are no longer a security feature. Now, if you look at that as a marketing scheme for Apple, that's probably not a big burden on Apple either, right? If you look at it as like Apple likes to tout its security, that doesn't sound very, very convincing. But if you look at that as the ability of Apple to sell to users a product that safeguards their information, then the burden, I think, is different. And one of the things that we argued strongly in our amicus brief is that when the court was examining burden, it shouldn't just be looking at the financial burden to Apple in the sense of, the expenditure of the engineer's time or the marketing hit, the loss of revenues to Apple if they were no longer seen as the company that got to protect security, but the burden on all iPhone users and all Americans if courts could order technology companies to defeat their own security. And that, I think, is a very profound burden indeed that goes far beyond just a corporation thumbing its nose at the federal government.
Yeah, so I know you're itching to respond, and I can feel it. But I do want to inject a little bit what I think is the perspective of the business, because I really like the fact that you guys are standing up for the businesses in this case, because I'm sure you will with Google and Facebook and in other instances, you'll stand up and back the businesses in that case as well. I really think the title should be privacy, security versus security. Right? So there's really two different types of security that we're talking about here. And I think the one that's important for my clients and for businesses is not necessarily concerned that government is going to do improper things with the data. Our issue is that in our jobs, what we're trying to do is make sure that our businesses, our clients' platforms are safe and secure. And anybody heard of ASUS, the wireless router company? Who got nailed by the FTC for having a backdoor in their hardware that was then exploited. So the concern for me as somebody representing a business is it's easy to say you can build something, because we all know that with enough time, resources, and money, you can build anything. The harsh reality for us is you ask us to build something that's for a law enforcement purpose, but there's no safe harbor once that backdoor gets opened. That backdoor gets exploited by a hacker. Pick your poison who that is. And now I'm having to defend a company against an investigation by the FTC and now the FCC, and now, name your poison. Everyone's getting into the information security regulation space now. Those are the difficult calls from the business perspective, especially since what we've been pushing all along is this concept of segmentation, segregation, not creating a weakness at the highest point within the within the configuration or the enterprise structure. I don't know how higher up you can get than an iPhone, unless you're a company that only uses BlackBerry, right? So my guess is that the majority of companies, if you created a potential security vulnerability at that device level, it's really hard to start arguing about segmentation. Does that make sense?
So let me talk to you a little bit about the world that I live in. Okay, it's going to be counterintuitive to what most of you think and the way you operate. For 225 years, we've had a standard of how the government can acquire information and what interests are recognized in terms of privacy. There is no absolute privacy in the Constitution. The Fourth Amendment talks about reasonable expectations of privacy and protects against unreasonable government searches and permits searches of property based on probable cause before a judge signing a warrant. In this case, we had a warrant. It was our phone. We also consented. We were Apple's customers, by the way, that weren't served by Apple's policy. But notwithstanding that, we don't have absolute free speech. You all know that you can't yell fire in a crowded theater. We don't have absolute privacy. U.S. Supreme Court 2 years ago in Riley versus California specifically said cell phones are subject to search. Now, it's a little odd for me as a prosecutor to see that I can search your home, your car, your business records, your medical records, your home computer with a search warrant, and now here's a device that's a Renaissance puzzle box that I can't search, and there's an expectation that that's okay. Well, we can make that decision, but let me give you some of the consequences of that. In most cases these days, criminals communicate, whether they be wholesale drug dealers, whether they be people that sext, whether they cyberbully, whether they make threats on the phone, whether they record crimes. photographically, which a surprising number of them do. And that type of information resides on the phone in a form that you know resides only on the phone, is not found elsewhere. And so if we can't search the phones, we can't even find the identifying numbers of the phones, the IMEA and the other numbers that we use to locate phone records and other ISP records, we can't get secondary sources of information. So what's that mean in the real world? Well, in our case, it meant that if there was evidence that indicated that there was a conspiracy, an outstanding co-conspirator in our shootings, that person was going to go undetected. We wouldn't have the tool to get that. Let's take another example. Suppose you have a daughter. Your daughter is abducted, and we find her phone, and you don't know the passcode. And we think that that phone will have information about where she was when she was abducted. It may have a photograph of the abductor, may have other important information, GPS locations, whatever. And we can't get into the phone because we don't have the passcode. That may be the difference between you seeing your daughter alive or never seeing your daughter again. I'll give you a more complicated problem for a prosecutor. Let me start with the last one. Common identity theft scheme these days is gas pump skimmers. Device installed in the skimmer, it steals the information primarily off the mag strip and then a PIN number, as you all know. Well, technology is involved. Instead of plugging those back into a computer, a lot of them are Bluetooth. So suppose we get a tip, we're able to find somebody that's skimming, and we catch them. And they've uploaded all the information, all that identity theft information from the skimmer onto their phone or their iPad, and I can't get that. I don't know where that information went. I can't protect you. I can't prosecute those people. Now for a prosecutor, I'll give you a nightmare. We are obligated to turn over all evidence that helps the defense, evidence that lessens the probability of guilt. Suppose I have an individual that comes to me, a defense attorney, and says, you have a phone in your possession, and on that phone is uncontrovertible evidence that shows my client didn't commit the crime. I have an absolute obligation to turn that over. I can't do that because I can't access it. So what is it that the expectation that we do? Do I proceed forward and prosecute someone that might in fact be innocent? Or do I let somebody that all evidence otherwise shows is guilty go because I can't get to that information? That's the real world, everyday, on the street level effect of this idea of total disk encryption. And it's not a math problem for us. It's talking to victims and talking to the survivors of victims and telling them, sorry, we can't get to this evidence because there's this concept of absolute privacy.
So,
Question.
yes, sir.
So, how is this different from the scenario when we go to a crime scene and we find a safe where we believe there's evidence of the crime? Government usually goes to raise the safe, right? Do they compel safe makers to punch back the safe?
The question was, what about a physical security issue? If you find a safe and they want to see the contents of the safe, can you compel the safe manufacturer to divulge a back door?
Well, I think the nature, that's part of the nature of the problem. Here you're talking about a fairly exquisite piece of electronics, all right? If it's a safe, we're going to try to get the person to open it. We may go to the safe maker and see if there's a combination that we can acquire with a serial number and have them provide it. Or we're going to take a blowtorch or an explosive and blow the door off the safe. We would probably seek to have them find a way to open the safe, yes. Just like if I went to serve a search warrant at a bank on a safe deposit box and seize the contents, we would compel the bank to open the safe deposit box for us.
Wouldn't you just allow access to the safe deposit box? You have the bank manager actually
Well, you know, what, to us, it wouldn't necessarily matter. I think that, wait a second, please. And the reason is that when the FBI asked Apple to disable the lock feature and the sequencing number, I don't know what expander, the time expander between
Large iteration count.
yeah, to defeat the brute force. The FBI actually went to Apple and said, do it. We don't want to know how you do it. We don't want you to get any of the contents from the phone. Just disable the alarm for us so that we can then do the forensic extractions. So, you know, it wasn't that we wanted that the FBI asked Apple to extract the data. All they said is give us the opportunity to use the tools that we already have to do that.
Have you had experience with law enforcement ordering a company to create something new, similar to what was asked here of Apple?
Really, no one could come up with an example where a company had been compelled to do something like this. There was a sort of a related issue that came up in a case about 10, 15 years ago called In Re the Company, is in the Ninth Circuit Court of Appeals. And the company's under seal, so we don't know which company it was, but it seems like it was something like OnStar, that, you know, provides the button in cars that lets you call 911. And what the government wanted this company to do was to change the way that worked such that they could use it as a roving wiretap of the people in the car. But it would undermine the purpose of the system, which was to be able to call 911 at the push of a button. And the court said you can't do that. It wasn't interpreting the All Writs Act, but it was interpreting a very similar technical assistance provision in the law. And really, no one has come up with an example where you know, the kind of assistance that the government wanted from Apple in this case had been ordered.
Right, I agree with that. It's a new issue, but Apple, in several thousand cases, has helped the FBI get into, or local law enforcement get into phones in the past. So this was a new stance by Apple that I think kind of took everybody surprised.
So I guess I had one question. Was there any discussion about having Apple turn over the source code
No.
to allow the FBI to build its own?
No. Well, not that I am aware of. I think that the FBI requested Apple to disable the pass lock so that the FBI could extract the data.
So
I think it's important here to make a distinction between what was actually asked and sort of what Apple was arguing against. In this particular case, what was being asked about was not the creation of a new backdoor. A backdoor already existed. It was inserted, presumably unintentionally, by Apple in terms of the way that they implemented the security that they believed would not even give them access to the device. But they had a bug in their reasoning and did not consider the particular vulnerability of their being able to sideload new software onto the device.
on the issue,
Now, much of the discussion has been about the broader issue of whether they should be forced to insert backdoors in new phones. And that's a completely different issue, one where I completely agree it's a bad idea to do. But with respect to what was happening here, they were being asked to provide the support to exploit the existing vulnerability in the phone.
so
That actually goes very similar to the issue of, you know, asking someone to help you crack a safe. It's not creating a new safe that's got these vulnerabilities. It is using technology.
So just a couple of points on that. On this terminology of a backdoor, we can kind of debate what a backdoor is or is not. You know, we at EFF, our senior technologist, wrote a piece about why, in his opinion, this is a backdoor, but it's a sort of a semantic issue, right? But they were being asked to exploit a vulnerability, and they were also being asked to sign it with their signing key, right? So that's a partial answer to your question about the source code, is that they were being asked to endorse it because otherwise the phone wouldn't accept the custom OS. So there's something about this exploiting of this vulnerability that makes it seem more like a backdoor. These are security features that Apple, in fact, you know, thinks were extremely important for the reasons that Peter was talking about, and they didn't want to defeat them. And so to them, that is about creating a backdoor and being forced to endorse it, sign the code. And from our perspective, or, the brief that EFF filed in this was all about why signing it, in fact, writing it and then signing it would be forced speech, compelled speech under the First Amendment. And so there is sort of an element of inserting a backdoor, whether you want to call it a backdoor or not. It's defeating a security feature that you don't want to defeat.
So you asked a question, rightly so. There are two issues. But the broader issue, I think, is the one that most of us are concerned about moving forward, which leads to this particular question: should the government be able to force companies to undermine their encryption? So I'd like to pose that to the panel. Peter, would you like to try to answer that one? Of course, lots of different answers.
Yeah, I mean, I will. We could talk about this one for a long time, and we got 15 minutes left. I'll make a very fast cut. I mean, obviously, we think no. And the basic issue is one that was mentioned earlier, that this is an issue of really security versus security, right? I think it's beyond question that there are criminal cases of the kind that the district attorney raised, that where getting at this information is useful to solving criminal case and makes a real difference in people's lives. There is also, as I think all of you know, there are also many circumstances where having secure encryption makes a real difference to people's lives and can be important. And the question is what that trade-off should be. So that's point one. And then point two is that it's one thing to say you have to force companies to create backdoors, but everybody knows that there will be plenty of people who are not creating backdoors, who are not selling their software through the open U.S. market, and you're going to basically get into a situation where if you outlaw encryption, only outlaws will have encryption. So what you're doing is undermining the security of most users in hopes of getting at criminals that may be sophisticated enough, if they're sophisticated enough to have a Bluetooth enabled gas station skimmer, they're probably sophisticated enough not to use Apple software that has a backdoor, but to find some custom software that does not.
So, I would say that government should not force companies to do it, but when I was talking before this panel, and I was thinking about those examples, I think all of us are problem solvers in the room, right? That's why I love information security, and even as a lawyer, I find a lot of commonality with InfoSec people because I'm a problem solver too. And I started thinking about this is that there has to be a means by which you can achieve a balance between, so when I approach an information governance issue and I'm working with a company, I'm trying to achieve a balance between business functionality, privacy, and security. And so, technically I can't tell you whether if we build a backdoor at the device level, if companies couldn't harden through defense in depth by implementing other security controls. My immediate response in getting prepared for this was, well, why didn't San Bernardino have an MDM policy? Right? So if they had an effective MDM policy, they never would have had to have gone to Apple. But, I was also talking beforehand that I doubt that the gangbangers have an MDM policy, right? I want to help. I want to provide some balance on this panel and just being objective and starting to think through those issues, as well as because I don't have a fear of law enforcement. In fact, I work with law enforcement a lot. There's probably a creative mind in this room that could come up with a solution and make lots of money.
So go ahead.
We are talking about a balance here, but let's forget, in real life, we do ask companies to do all sorts of things that they might not otherwise be inclined. We don't let them dump hazardous waste in the bay. We don't let them, put defective products in commerce without some consequence or some government order to correct that. And I think the last time that we really saw an era where corporations decided these issues on their own, based on their own interest, was the Standard Oil and the Southern Pacific robber baron era, and I don't think that's really, that's a one-sided issue. Just like I don't think law enforcement is asking for total unrestricted warrantless access to these areas. It's a problem that you people are probably well better able to solve than I am. I'm the end user of this product. I don't doubt that you people and as a country, we are smart enough to do this and figure things out. Certainly the criminals are working on this in Eastern Europe, North Africa, and other organized crime areas. Governments, China, North Korea, parts of the former Soviet Union, as you know, are engaged in daily attacks on your infrastructure, on government infrastructure. So we can let them find an answer, or we can work to find some suitable answer that strikes a balance between reasonable expectations of privacy and government needs.
Your point is exactly to this next question, which I think is the crux of the whole issue right here, folks. All right? Can both our country be safe and our citizens' privacy protected? And the second part of that question, and this is a tough one to answer, what trade-offs are the American people willing to live with?
So, I think this actually goes to this question as well as what we were just talking about, which is this is a room full of people that know how hard it is to build security. This is a room full of people that understand that if you insert vulnerabilities and then try to harden around them, that's a bad way of building systems. We can talk about balance, and we can talk about setting a balance between the sort of national security and the security of devices, but when it comes to asking the experts how to do that on a practical level, they're pretty much unanimous that you can't build a backdoor that only good guys get access to. That's just not how the technology works. So when you look at the leading cryptographers, what they say, now, this is a bad idea. There's a paper that came out of MIT called Keys Under Doormats that I'm sure many of you are familiar with. Sort of the state of the art in how could we do this? Well, it's not going to scale. It's not going to work. And you can sort of think about all the reasons why that would be. You have high value keys that are then targets for the same malicious actors who are conducting crime. You have governments that don't respect human rights that are going to want their own versions of this. So when you actually start building these systems with a backdoor that we can get access to with a warrant, you start to see all the flaws and where it would break down. So when it comes to setting this balance, we can set that balance in how warrants are issued, what other kinds of communications there are, what other forms of surveillance there are. But when it comes to the building of the security, there really isn't a balance. The policymakers are saying nerd harder, and the nerds are saying we can't.
So now you'll see that I'm a true Gemini. Because I was with you until I don't think that necessarily the companies that I work with or that are generally dealing with information security are the same as somebody trying to hide spilled oil in the Gulf. In fact, it's quite the contrary. I think companies are trying to develop infrastructures and systems that provide first business functionality, but then security. And I think that's the real crux of the issue for us, because information security is often a second thought in the development of applications, and so the resources aren't there for the integration and the baking in of security when those products are created. And so when I talk about defense in depth, and actually having multiple layers of security is important. So if we know from our perspective that we have security at the device level, that helps us to allocate our limited resources within the company to implement other information security controls. So on the I can appreciate it. I understand that there's a need to reach this balance, but the other practical reality is that until there's more emphasis on information security in the app development or the product development lifecycle, we almost somewhat depend on some of these third parties in order to provide further robustness to our information security controls.
Yes, sir.
Yes, hi. Can any of you speak to what is being looked at in other comparable countries, like let's say Northern EU, with regards to dealing with this issue from a technology and also privacy rights standpoint? And also, are there any technological architectural solutions that can be employed, such as having somewhat of almost like a national security letter of review that would be comprised of civil rights, let's say 2 attorneys, 2 people from industry, 2 people from judicial, and you have almost like a kind of multi-factor random generator launch key system, a super majority, whereby which you case, which would then allow that one time to allow access to that device.
So I would really direct you to that keys under doormats paper that I was talking about. It's by the sort of, yeah, so that's not how encryption works. I mean, that's a key escrow type system that you're describing.
So,
Multi-factor authentication to get into the device.
so let me tell you how search warrants get generated. Sometimes we're lucky enough to have search warrants that come during business hours. There are an awful lot of judges that get calls at 2 o'clock in the morning to have a search warrant authorized at 2 o'clock in the morning because we need to search information right then. And it's done by a sworn affidavit of a peace officer establishing probable cause on an ongoing investigation. That information is not going to be shared with a business or other individuals. It's an application by law enforcement to a judge who is empowered to either grant the warrant or not. So, I mean, there's not really time for a committee debate on these things.
I'm going to ask one more question because we're almost out of time, and this is one that several people have presented to me, so it is kind of an audience question. And it's a little bit of a side thing, but it's really important. And that is, should law enforcement share their hacks into technology companies' software much like researchers do? So in other words, FBI hired a company, they hacked into the iPhone, and now there's a vulnerability that they're not disclosing. So would anyone like to tackle that one?
Yeah, so I think the answer is yes, and you don't really have to take my word for that.
Can you let him
You don't have
finish,
to take
please?
my word
Hold
for
on.
it. You can listen to the White House Review Group on Communication and Surveillance Technologies, whatever it's called, appointed by President Obama, where they said in most cases.
Okay, so my perspective, hang on one second. My perspective is if we're plea bargain,
Everyone, please calm. No, this is an emotionally packed issue. I get it. Let the speakers respect our speakers, please, everybody.
I'll wrap up. So this is the policy of the U.S. government currently, is that in most cases, for most vulnerabilities, it's a good idea to disclose to the companies. That's actually the policy of the United States right now.
right. Okay, so if we're talking about plea bargaining here, what are we getting back from this? And remember, most local law enforcement doesn't have the resources of the FBI or the Department of Justice. Your local police department is not going to spend $1 million on a phone to be able to get into it, okay? So the question is, if there is this idea that the FBI or whomever, not really the FBI, whomever they hired to do this, and assuming it's not proprietary and all those other niceties, if it's going to be provided for Apple, what's Apple going to provide back to law enforcement or to the U.S. government? It doesn't make much sense for Apple to have an absolutist policy saying we're not going to cooperate, but help us fix so we can't cooperate anymore.
Right.
I mean, that's a bad bargain.
Just to go back to what I was articulating as the burden from this, I think that the argument is that what Apple is giving back in return is security for all its millions and millions of customers. Right.
It's not giving security to the families of dead victims, families that are victims of identity theft,
But to draw an analogy back to the physical world, right? There's no question that the police, the FBI, have a right, if they think there's evidence of crime in my house, to get a search warrant, to come and enter my house. But that doesn't, I think, entitle them to prohibit me from putting doors on my house so that it makes it easier for them to get in. And if the cops come by and notice that my locks are broken, I would hope that they would tell me so that I could fix it and keep criminals out, even though it might make it harder for police to enter in the eventuality that they wanted a warrant. That they got a warrant.
So I think one of the issues as well is once a vulnerability is discovered, and can you keep it under wraps? We've seen top government agencies hacked. So once it's out there, how do you control it and keep it from being misused by somebody else, possibly for political purposes even? Who knows? Any final words from our panelists? Never such thing as on this topic as a final word, but
Well, I mean, isn't that the whole concept of the arms race we're engaged in now, is you build security and there's some crook that's or government that's trying to defeat that for their own purposes? So aren't we better having control of that method? I don't think that Apple's source code has been stolen from their safe, and they managed to protect their trade secrets, as do most other people. It's a more complicated issue, certainly, but my thought is, if you control the process and you have some information on it, you're better off than letting somebody else dictate the course of events.
So it really is a question of where we want to be investing our time, whether we want to be building security or whether we want to be undermining security. And in the opinion of people like you, in the opinion of people in national security, it's the most important thing is to build security. The police have a job to do. We're not saying they don't do it, but they've done their job throughout history. There have always been times when they couldn't get access to information, and they've done their job nonetheless. That's on one side, and whether to build security is really the question in one of these debates.
Peter, any last words?
Yeah, I mean, I don't go, particularly on this question, go back to the idea that government has never had great success with passing laws that cabin the technology and cabin more than technology. It's essentially what it is that we're allowed to build and to speak. I mean, to the extent that code is actually just speech, and I think it's an artificial construct to think that. It's an illusion to think that you can actually just pass a law that says that law enforcement will always have access to electronic devices, and it will be so. What will happen is that most consumers will suffer from that artificially stunted technology, and that sophisticated criminals will continue unabated.
I want to thank our panelists. And you guys, keep this dialogue going. This is just one panel, but this is a key issue, the fabric of the United States and of the world, right? Technology, privacy, security. So I want to thank, a big round of applause. These guys work hard.